Ona mihi maoha, tēnā koutou katoa. My name's Fleur Fitzsimons. I'm a National Secretary at the New Zealand Public Service Association, and I'm here with union lawyer Peter Cranney. We want to tell you a bit about what the union movement has done in response to the government cancelling pay equity claims and gutting the Equal Pay Act, which happened on the 7th of May 2025. And in response to that, there was a huge uprising all over New Zealand of women, men, mums, dads, aunties, uncles, grandparents, all appalled by what this government had done to New Zealand working women. The union movement committed to leaving no stone unturned in highlighting, campaigning and opposing what this government had done to pay equity. An important part of the opposition and an important part of our campaign against what this government did was taking action in the High Court. We took action under the New Zealand Bill of Rights Act, and Peter Cranney, along with Dr. Rodney Harrison, KC, were the lawyers acting for the unions. And so we want to talk to you today about what happened in the case, why it was taken, who took the case. So Peter, can you first tell us about the background? Who were the plaintiffs in the case?
Well, they were the 5 biggest female unions in the country, and that was the PSA, of course, the New Zealand Nurses Organisation, the Post-Primary Teachers Association, the NZEI, and the Tertiary Education Union. And all 5 of them are plaintiffs in the case before the High Court.
And tell us about the case. So what are the unions asking the court to do?
Well, just to explain the case first is to look a little bit briefly at the effect of the new Act. I think you've correctly described it as essentially destroying many equal pay rights, if not most equal pay rights. And the new legislation imposed, first of all, the cancellation of all existing claims, which in order, if they are to be progressed at all, now have to be refiled and started again. Now, many or most of these have taken a year or 2 years to get to the stage they were at, so they have been cancelled. The other major changes to the Act are that anybody now who settles a claim or who has settled a claim must wait for another 10 years before they can file another claim or seek to have their pay rate, their pay equity rate, updated. So that's the second big change, and it is now to be unlawful to try to address pay equity at all in that 10-year period. And the third biggest change is the cancellation of what we call review clauses. So all existing pay equity settlements had to include a process to review the pay equity pay rates in those settlements, so that every 3 years at least, the parties had to draw their attention to that issue and to try to ensure, to use the words of the statute, that pay equity was being maintained. Now, all of those review clauses have been cancelled by the new Act. So even though many of them are in both pay equity claim settlement documents and collective agreements. So the Crown has removed those or the Parliament has removed those contractual provisions from those documents. Now that's the first part of it. The second part of it briefly is that the new requirements for any claim now raised are so severe and so onerous that it's very unlikely that any or many claims will be made, and if they are made, they can be successfully prosecuted. So there is a whole series of provisions within the amended Act which are barriers or methods of stopping claims from being advanced, including quite a number of rights to the employers involved, who at various stages of the process can discontinue the claim unilaterally by employer decision. So it is a rather severe and intense attack on human rights in the country.
Yeah, we described it at the time as a form of constitutional vandalism and wage theft. And on budget day that year, we saw that it was $12.8 billion that had been set aside for settling these pay equity claims. What was the context that you raised with the High Court at the beginning of the trial?
The Crown's case at the trial consists of an argument that they were genuinely trying to introduce appropriate law reform. However, the union's argument, based on the evidence, is that it was never a case of genuine employment law reform. There's no evidence of any attempt to do that. It was done in secret. It was done over a very short period of time, and that the main driving motive of it was fiscal. So the Crown as employer using the process of so-called law reform to in fact save that sum of money that you've identified. That is the initial extent of the discrimination, which is the result of it, the $12.1 billion.
So can you tell us about, who was in the court, how it operated, who speaks first? How does it play in practice?
Well, the defendant party was the Attorney General, represented by a number of lawyers engaged at the Crown Law Office. And the plaintiff parties were the 5 unions to which I've referred. But there was also a very important intervener party, and that is the Human Rights Commission, who themselves lent their support to the sorts of ideas and submissions which were being advanced by the unions. That is, they argued along with the unions that the legislation breached basic rights under the New Zealand Bill of Rights Act, and that is, first of all, rights not to be discriminated against on the basis of sex, and secondly, rights to be natural justice rights to be properly consulted before a very serious decision of this nature was taken.
And we did see that, right? We saw this happen with no prior signalling, under the cover of darkness, no parliamentary select committee process, really nothing that women could see that they could have their say about their claims, about their pay, the inequity they face. And how significant is standing up against that?
Well, we won't see what the judgment says, but in terms of the way it was done, it was very unusual. That in the absence of some national emergency, one would not expect a process where something so significant is dealt with in a day or two by Parliament under urgency. And I think that weakens the Crown's argument that it was a genuine law reform process, and I think strengthens the arguments made by the 5 unions and the Human Rights Commission that it was not so.
And one of the arguments I know that you advanced in the court was that this is about more than just pay for women. Can you touch on the significance of this case and why it's so important in New Zealand society?
Yes, pay equity has got a long history as an issue in New Zealand. And when I say that, it predates the Government Service Equal Pay Act in 1961, which was a pay equity act, pursued mainly at the time by the Public Service Association, and the 1972 Act, which tried to address this issue, and the subsequent efforts since then to pursue pay equity. It's not an issue that can be seen in isolation from the general discrimination against women and women workers in society generally. Because if people have been brought up in a society where women workers are paid less for the same sort of work when compared to male workers, and everybody recognises that that exists and is a fact, it has a broader impact on the attitude of society towards women and towards women workers, which is so the pay equity issue is an important component that needs to be addressed in trying to advance women's rights to an equal status to those enjoyed by males.
Now, you also described during the case that the approach of the government and the new legislation was dystopian. Can you explain that?
The difficulty is that the result they achieved is that in an act which is called the Equal Pay Act, tens, if not hundreds of thousands of women workers are prohibited for long periods from taking pay equity claims. And in fact, discussion of pay equity is substantially outlawed for many workers, many female workers, for the duration of the 10-year period. And it's an act, the government's argument was that the act wasn't working, and that's why they wanted to change it. But the problem really was that the act was working, and it was beginning to address pay equity, and that they didn't like that result. That was our argument. And when I say it was working, I mean it in this sense, that society was beginning, difficult though it is, to put energy and effort in a commitment to try to work to resolve this issue in a genuine way. And that's exactly what employers and unions and members were doing over those periods. Of course, it was time-consuming. It was often difficult. But the ideological goal was beginning to influence New Zealand society in a positive way. And that's why the issue is so important and why we should not give up on it.
And it seems obvious that it's discrimination and it must be unlawful under the Bill of Rights Act. What arguments did the Crown advance to defend their position?
Their primary argument, I think, was that it was a genuine attempt to make the system work better. But we think that argument is very weak. That was their primary argument. There were other arguments which probably are a little bit too technical to go into, but they criticised various ways in which the unions advanced their claims, and that will be now dealt with by the court, and we're optimistic that we're okay on those grounds.
So there were 5 unions who were part of this claim. How did they advance their arguments? How did they get across what is wrong with the Equal Pay Act?
Well, what happened was that each of the unions contributed evidence to each of the 5 unions separately contributed evidence to the case. And that was done in affidavit form. Just by way of example, Joe Brunskill from the Post-Primary Teachers Association explained to the court that the changes had in fact eliminated any possibility of secondary teachers advancing their claim. Stephanie Mills gave evidence on behalf of the primary and early childcare workers, and her argument was that various claims had been cancelled, various review clauses had been done away with, and that the new system was unusable and retrograde. And for the Public Service Association, quite a comprehensive affidavit from Alex Davies, which summarised all of the settled claims from which reviews are now prohibited, summarised all the claims which were underway, which have now been cancelled, referred to some claims which can't now be progressed at all under the new system, and also emphasised the unworkability and regressive nature of the new statute. And similar points were made on behalf of nurses by Glenda Alexander, who pointed out that the nurses in Te Whatu Ora, for example, who had a review process agreed, that's now been removed from them. They're prohibited from any claim until 2033. And they also make the same points about the workability of the statute. And last but not least is the Tertiary Education Union, who Amy Ross and others gave evidence, provided evidence that their claims tended to be a bit smaller than others, but they were a very important group of workers. The administration workers in universities and in university libraries have now had their claims cancelled, despite having worked for at least 2 years in advancing those claims And of course, the same point made about the remaining rights are so sparse and so unusable that they can't deliver any progress in pay equity for that group of workers, almost exclusively female and a very important group.
A huge amount of pay equity expertise in those union witnesses. Who did the Crown put up?
The Crown's witness was the head of MB, Nick Blakely, and his evidence was designed to support the perspective that this was indeed a genuine law reform, despite its unusual nature. He did accept, I think, that there was a pecuniary motive for what occurred, and the court will make what it can of all of those witnesses.
We knew the courts would give us a fair hearing even when Parliament hadn't, and it was worth it just for that. But what are we actually seeking? What would a win look like?
The formal remedy is a declaration that the actions of the state in the form of the executive and Parliament are contrary to the rights protected in the New Zealand Bill of Rights Act against discrimination and due process. So that's the formal remedy. However, if such a remedy is granted, it does have some consequences for Parliament, because the Bill of Rights Act contains a new provision brought in 2022, which now requires that such a declaration by the High Court be taken to Parliament, and the Attorney-General is obliged to then present that declaration to the House 6 sitting days after it becomes final. So there might be other appeals. So the Attorney-General must, if that declaration is made, draw it to the attention of the House, and then the responsible minister is also required to report to Parliament the government's response to the declaration. Now, in addition to that, it appears that there are provisions now in the standing orders of the House itself which make clear that the matter would be referred to a select committee of all parties and be addressed there. So the important aspect of all of that is that it forces the country to focus on the human rights aspects of what has occurred. And what then follows from that will depend to some extent on what the declaration says if we do get one, and also on the makeup of Parliament at the time the report is made. But it's a very important continuing focus among all the other things that we're doing. So it's not to be over fascinating to people, but amongst all the things we're doing, it's an important element of trying to protect and advance these human rights, which of course we've been committed to, and we always will be, and you'll get setbacks and steps forward, but we just keep going with optimism and so on.
And look, I just want to acknowledge you and Rodney Harrison and Kathleen as the lawyers for the unions. A huge amount of time and effort went into the case. At the end of it, 3 days, did the judge give any indication about when we can expect a decision?
Only to say that he would deal with it promptly and expeditiously, which I think he will, and we'll just await respectfully His Honour's judgment.
Thanks so much.